Hi, I'm Claudia Brown Coulter with Pivotal Peace. I'm your go-to mediator for navigating divorce while parenting children with special needs, and I'm also a legal document assistant, LDA, based in the greater Los Angeles area. So you have been served with divorce papers. Your spouse has filed. It's a surprise or it's not a surprise. Either way, you have been handed some blank forms, and one of those blank forms is the FL 120. This is your opportunity to respond to the divorce. Maybe you agree with everything your spouse said. You can still file a response. Maybe you disagree with everything your spouse said. You can still file a response. Here is the power of filing a response. If you ever need to go to court, the judge has the ability to talk to you. Without it, you don't have standing in court. You have to have this filed if you want to speak in front of the judge regarding this case. So let's talk about what it entails, the sections you might need to fill out, and how to approach this. Okay, so this is a response, the FL 120. This is the form for California. As I've said in other videos, you're going to need your name. If you're not represented by an attorney, then you're going to be the one filling this out, or your legal document assistant, but then they don't need to watch this video. You need to know what should be on here. Your name. If you're not an attorney, then they don't need your firm name. They're not asking for where you work, right? This is the law firm. Your street address, your city, your state, and your zip code. Your telephone number, your email address, and then if you're represented or not. So if you're represented by an attorney, your name would go here and everything else would have the attorney's information here. But since you're not represented by an attorney, you're pro per. Then you're going to also put the county where you are filing, and this is where your spouse has filed. And you're going to look at the address and the branch name. Now, it's really great to have your spouse's paperwork in front of you, so you don't need to go online and look it up. You can see right there, okay, they filed at the Central Courthouse. They filed at Stanley Mosque. Great. This is how, okay, they used a middle initial for themselves and for me. Okay, I'm going to put that down exactly. This is our case number. Your case number is on the FL 100. You're going to type it on there. If you're in Los Angeles and you filed in the Central Court, Stanley Mosque, and say, you filed in 2024, then you're going to have some numbers here, okay? That's usually what it's going to look like. I think that's too many numbers. All right, so this is a response and request for. And then, are you dissolving this? Are you getting a divorce? Is this legal separation or is this an annulment? So even if your spouse said they wanted to legally separate you, you can ask for a divorce instead. Okay, and then is it a dissolution of a marriage or a domestic partnership or both? Totally fine. Then you need to answer number one. We're married, we're domestic partners. That was established in California or not established in California. Then who is a resident? It is both of you or it's one of you. It's okay if it's not you. It's okay if you live in Michigan and your spouse lives in Los Angeles. Then you would put that the petitioner is the resident. That's totally fine. And then these are additional information about domestic partnerships. They want to know, this is about your marriage and this is about domestic partnership. So if you were married, they want to know your wedding date, right? So let's say you married on New Year's Day, 2016, okay? And then the date of separation. The date of separation is not legal separation. It's the date when you're like, this marriage is done. Either you moved out or maybe you moved to different bedrooms, or maybe you said, you know what, this is over. We're getting a divorce. We can't afford to move out. Okay, so maybe it was just a rotten Valentine's Day. And so you're like, you know what, 2024. So then the court wants to know from this date, your date of marriage, to your date of separation, how long was that? Not to today, unless today is the date you're putting in. They want to know what is the difference in time between these two numbers. We're going back to like fourth grade math. Okay. Are there minor children? Yes or no? If there are, minor, under 18. The court's going to be like, I don't care about this 19-year-old. You and I both know, and so do the clerks know, that children who just because they're 18 does not mean they're self-sufficient. Don't worry about that. They just want the minor children, okay? They need their name. I suggest putting their full name on there, their birth date, and their age, their current age. If you're pregnant or your spouse is pregnant, you're going to need to check that box. If you got a whole bunch of kids, great. You can add them on. All right? Some people have children who were born before the marriage. This is for you, okay? They need some sort of voluntary declaration of parentage or paternity. Then, let me go back here. Every once in a while, I get a client who's pregnant but not by their spouse. They still have to list that there's a child who's not, they have to still account for it somewhere that, hey, because paternity is assumed in marriage. So you could be pregnant, but it ain't your husband ain't your baby daddy. That's okay. That is okay. We just have to make sure that the court knows that this baby does not belong to this man. And usually your spouse is like, cool, because I ain't paying child support for somebody else's baby, right? I just need you to know that you got to make sure you account for that. Okay, we at page 2. There's 3 pages, page 2. You got to put your name and their name again. You got to put your case number again. Legal grounds. Legal grounds. Is it that you were never legally married? Is it that what they put on their petition is wrong? Like maybe they said you were insane, right? Or are you just going to go, hey, I want a divorce because of irreconcilable differences? Great. Done. Then you also need to list, if you don't have children, you can skip this part. How is legal custody going to be decided? Is it going straight to the petitioner or the respondent or joint? Okay. Is physical custody, are they going to live with both folks or just one? Okay. Child visitation really comes into play when one person has sole physical custody, then the other person would have visitation. And you can list the visitation here, or you can save that until the final step. Okay. And then there is information about child support. You don't have to list child support on this form if you don't want to. You can figure that out at the end. Let's talk about spousal support. Is there going to be spousal support? Are you going to pay support to the petitioner? Okay, or do you want them to pay support to you? Are you going to terminate spousal support to you and to them? Okay. Ooh, this does not want to click for me. Okay. Or are you going to reserve jurisdiction? Maybe it's like, we're not sure what we're going to do yet. So let's just have some more conversations and then we can figure this out later. And it could be that, hey, we're going to reserve jurisdiction and we may need to come back to the court later. So after our divorce, fine. You need to make a decision about separate property. Yes, you can list all of your separate property in FL 160. You can say that there is no separate property, or you can say, yeah, there's separate property. I don't want to list them all right now. So either I'm going to just list a few things out, or I'm just going to put something vague here and says, we're going to figure it out and we'll make sure we detail it in step 3. That's what a lot of people do. Page 3, same thing. You got to take care of this header. Their name, your name, case number. Community property, same type of thing. Is there community property? Some people, they say that they don't have any community property because they've been separated for 10 years and they've already divided everything. But if there is community property, you got to list it here. So once again, you can do the FL 160 and submit a detailed form of the community property, or you can put something vague in here that, yeah, there's community property and we'll figure it out later. It's up to you. If you keep it vague, though, it allows you to kind of get through this process faster. Now, attorney's fees. An LDA, a mediator, those don't count as attorney fees. Attorney's fees are fees for attorneys. who's going to pay these? Now, if you're each going to pay your own fees, great, right? But if maybe you make 10 times more than your spouse, or your spouse makes 10 times more than you, and you might need a lawyer, then you can ask the court, hey, you know what? I'm going to need the petitioner to pay any of my attorney's fees. Did you change your name in the marriage? And if you did, do you want it restored? Now, just because the court has restored your former name doesn't mean it's totally done. You still have to go to the Social Security office. You still have to go to DMV. But what this does do is once your divorce is finalized and you've made sure you included, you want a name change and what you want to change it back to, when you are ready to change your name, even if it's after the kids are grown, you have an order that says you can change your name. So you don't have to do it right away. And then anything else that you're requesting of the court, you can list it here. You need to date, print your name, and then sign your name. Then there is a fee still for the court that you need to pay. It's anywhere between $435 to $475 to process this response. Okay, so as you can see, it does not take a lot of time to fill out that response. You can sit down and fill it out in one sitting. If you have children, you would also need to fill out an additional copy of the FL 105. Your spouse filled it out. You'll need to fill that out as well. That form is explaining where the children live and where they have lived the past 5 years. The court needs to make sure they have jurisdiction to make decisions over that child. You will also need to serve a copy of this on your spouse. Have someone serve your spouse. Okay, and then you need to file the proof of service with the court. But for sitting down and filling out this response, it doesn't need to take you long. You can totally do that. If you need help, though, I am here to help you. Have a great Thursday.